You're now live.
We are now live. I've got one or two things I wanted to run over with the committee first. First was that 169 that hit the floor today. I apologize. Normally I would have the committee look at amendments. I didn't know until I looked at the email this morning that it was coming up a month ago. Jane said, why don't we just put the money on the budget adjustment? That's all I heard about it. So I didn't know that was coming up since it just sent the money back and didn't change anything. I was getting set to stand up and say, well, finance hasn't seen this, and unless someone hollers, no, I don't think we'll disapprove. But Senator Pierceman beat me. So that was that.
Thank you, Madam Chair. I just, that was a tiny one, but in general.
No, in general, no, we always go over it. We usually don't know, and it's just worse now because we're not in the building. The other thing is we are taking up that genetic testing and insurance bill, and we have a request from Jason Williams, who's with I believe UVM MC, and he's been following that bill for working on it for 4 years. He would like to just be on the Zoom, not as a witness in case we have questions. That's something that we don't usually do. So I wanted to make sure it was okay with the committee, understanding that once we do it, there will probably be other people, maybe after the town elections, but if that's okay with you, we'll do that. All right, so we'll get back to today's agenda, and we are taking up S53, which is the corporate income tax changes, despite the title. And we're still trying to work our way through marking up. But we have Catherine Michaels with us. She is here, your CPA, and the Chamber of Commerce we had asked to hear from them, and she's come to us to talk to us with their perspective on this bill. So Ms. Michaels, we just ask you to introduce yourself for the record, and then the floor is yours.
Thank you so much, Senator Cummings, and I appreciate the opportunity to be before you all. I hope I can be of help today. My name, again, is Catherine Michaels. I'm with the firm of Rath, Young & Pignatelli, which is based out of Concord, New Hampshire, but we have an office in Vermont as well. And I have prepared testimony just to help you all. I hope you all have that. It was suggested that I post it. Would that be helpful, Chair Cummings?
Yeah, it probably would be helpful if you can screen share, and it. I'm sure it is under our documents if you send it in, so we have it for future reference.
Sure. Can everybody see that?
Not yet.
Okay.
It says you're screen sharing, but it hasn't come up.
1 second, please. Let me try that again.
And we're back. Faith, can you screen share? Do you have that you can share?
I can. If you hold on, I will post it and share it.
Thank you. I apologize. I think that kicked me out, so I don't want to do that for you all.
There we go. Okay, something is up. So
can you see it?
Yes. Might make it a little
I cannot,
larger.
but there we go.
That's
great.
perfect.
Thank you. Thank you. So, Madam Chair, my thoughts were to go through a little bit of the beginning of this outline, and then jump to maybe not in chronological order, but jump to some of the more material provisions, if that would be acceptable to you.
Yes.
Okay, great. I've put my background on there just so that you all understand my perspective. I'm here in my personal capacity and not on behalf of any clients, past or present. I have approximately 20 years in the state tax field, 15 of which have been in New England. I have been a Vermont tax lawyer and licensed in Vermont since 2013. And as my background lists, I've had the opportunity to work on a number of great tax initiatives in the state of Vermont. So one of the things I wanted to do, just to provide a backdrop to you all when you're considering the provisions in Senate Bill 53, is to provide some of the overarching tax policy considerations, which I have in Section 2. One of the things that I think is important to recognize, and I think you all probably know this by now, is that there have been significant shifts in corporate income tax sourcing at the state level over the last 5 or 10 years. I believe you all know this because Vermont went to market-based sourcing a couple of years ago. And all states actually now in New England, all 6 states have market-based sourcing for services. The other element that is really a trend across the country and that is part of Senate Bill 53 is single sales factor. And all 6 New England states, but for Vermont, have enacted single sales factor. And I believe this committee is aware of that because I noticed that Commissioner Bolio provided you with a great Venn diagram to kind of tell you where you are in the country as well as in New England. One of the last points that I'd like to make, and Faith, if you wouldn't mind just scrolling down to that subsection D so that you can see all of it, is to mention sort of, Vermont and New Hampshire are very similar, right? We're both small states, and we have what I think we term as sort of small state challenges when you look at tax reform. And what that causes us to do, or should cause us to do, is really think about what we're trying to enact and what it will do to our economy and our workforce. In many respects, we cannot, as small states, afford to be an outlier on significant tax issues. It's just too easy to move. We are not Massachusetts. We are not New York. We have to maintain a business climate and a tax structure that attracts not only a mix of businesses across the industries, but also provides a welcoming climate to small business as well as large business. And that, of course, supports a young, skilled workforce in the state of Vermont because we have similar challenges in the state of New Hampshire. The last point I'd like to mention on sort of the overarching considerations is that it's very easy for a corporation to move 1 or 2 hours across the state line. Your neighbor to the east, which is New Hampshire, has, and I think you all know this, has no personal income tax, no sales and use tax, and we have a top rate of 7.6%. So, I think, and this applies to both states, Vermont and New Hampshire. We have to be very careful about looking at tax changes that might drive companies out of the state, and across the border. And I've been involved in a number of those situations with respect to New Hampshire and companies considering leaving and going to Massachusetts. Particularly before New Hampshire enacted single sales factor, which went into effect in 2022. So I just wanted to provide that backdrop because I think it's really important when you consider any type of major tax reform bill, which is really what you have in Senate Bill 53.
Madam Chair?
Yes, Senator Pearson.
Would it be okay to interrupt with a question?
Yes.
So these are some strong assertions that you're making, but your example seems counter to the very data or assertions you're making. But why would a business be tempted in a tax policy setup? Why would any business be interested in moving from New Hampshire to Massachusetts? They're in every way, I would have thought Massachusetts is less tax friendly to business.
Thank you, Senator Pearson. That's actually a great question. There are 2 examples I can give you. One is that we were a 3-factor formula prior to 2022, and Massachusetts for most industries is single sales factor. So it does present an opportunity for companies to move into the state of Massachusetts and not be penalized for having an office or an employee in the state. Another example I can give you is that New Hampshire's taxation of foreign dividends is very aggressive. And we basically tax foreign dividends as they come in over an apportionment factor as compared to Massachusetts, which for the most part provides a 95% DRD. So you're only taxing 5% of the dividend. In Massachusetts, you're taxing a significantly amount more at times in New Hampshire, depending upon the foreign apportionment factor. One last point on that is that Vermont's existing foreign dividend taxation provisions were modeled after New Hampshire. So Vermont and New Hampshire have the same provisions.
And so the statement just really stands out to me. Cannot afford to be an outlier on significant tax issues. Compared to New Hampshire, we're a huge outlier on tax issues, and you know, none of us, I don't think, are going to eliminate the income tax in Vermont. And so, you know, by your logic, we've already lost. But you're a numbers person. So where's the data that suggests that without absent this change, we will see a drain of businesses? You know, nobody is really backing up what you're saying with data, and our own fiscal office is unable to provide evidence one way or another. So you must be offering data, I'm sure, because that is not an opinion. It seems like you've stated it just as a plain fact.
I don't have any data, and it would be hard to find that, because what you're asking for in some instances is, can I give you an example of a company that considered moving into Vermont and decided not to because of its climate? My comments come more from my experience over 20 years and being part of discussions with various multi-state companies that have assessed the tax cost in various states. And it ranges from, you know, the top rate to apportionment to throwback, minimum taxes. It's a full package, just as they would measure the overall, you know, burden for non-tax reasons, right? I hope that answers your questions, but I don't have data, and I think that data either way is hard to come by.
Thank you.
Sure.
Okay, any other questions at this point? Okay, thank you. I think we can go continue.
Sure. And not to cause any confusion, but I want to jump around a little bit.
Okay.
And I can't move the document, so I apologize, but I wanted to jump to the two more material provisions of what I view in Senate Bill 53, which is single sales factor, which is in the outline subsection C on page 2.
Yeah, we've got that up now.
Okay, great. And also the repeal of throwback, but I'll start with single sales factor. Overall, and again, my comments come, you know, I represent a wide array of business. I've represented small businesses in Vermont that are not even multi-state. I've represented large multinationals. So, you know, I have a background that is diverse. And again, I'm not speaking on behalf of any of those particular clients. This is simply from a tax policy standpoint. With respect to single sales factor, I think it's beneficial for Vermont to consider single sales factor for a variety of reasons. As we mentioned before, all 6 New England states have single sales factor, but for Vermont, it is a clear trend across the country, and it is consistent with market-based sourcing, which has already been enacted by the state, because both are focused on the market and not the factors of production. In this respect, it's a modern approach reflecting what is sort of the trend across the country, as well as, and I probably don't need to tell this committee, we have an increasingly mobile workforce, particularly due to the pandemic. We can work anywhere. I'm speaking to you from, you know, my home in New Hampshire. And so when you think about the sales factor, it reflects that modernity of, you know, we're going to have people in offices moving and working all over, but what is consistent are where a company is making sales into. Because of this, I also think that single sales factor is good for the economic development in the state of Vermont. It will encourage in-state migration of companies, which is going to support your workforce. And with that, the potential for increased tax revenues coming off of sales and use tax, personal income tax, increase in home values, and so forth. So overall, I do think that there should be consideration given to the single sales factor section of Senate Bill 53. Before I move on to throwback, I want to open it up for any questions.
Any questions? I can't see you, so you'll have
Madam
to
Chair?
holler. Yes, Senator Hardy.
Yeah, I just want to reiterate something that Senator Pearson just brought up. You just said, Ms. Michaelis, I'm sorry if I'm mispronouncing your name, in response to Senator Pearson's question, that you have no data to prove any of the economic development assertions that you're making. And this is a conversation that we've had with our own tax commissioner, and he's backed off on the economic development assertions. There is no data. You're just speaking in conjecture, and it's not helpful to us who are trying to make public policy decisions when you're just speaking anecdotally and with conjecture and not showing any data to prove your point. So I really am not pleased with the repeated nature of the economic development argument in this case. There are other arguments to be made for sure, but that is not one of them. Thank you.
Okay, I think the testimony was that that data, if it's available at all, is very hard to come by. Companies don't publish why they choose to move somewhere. I believe what Ms. Michaels said is that she is just telling us what she's learned through her discussions as a tax attorney with a variety of companies, big, small, and indifferent. And that's her area of expertise. So I think we can listen to her, but we haven't seen any countermanding data either. We were told the data doesn't support that, but we have not been given any data. I have a feeling for the same reason. So at this point, there is no data on either side. And I think we can continue. And maybe we should limit ourselves to points of clarification until we get to committee discussion. So Ms. Michaels, you want to continue?
Sure, thank you. And I appreciate your comments, Senator Hardy. And I guess the point I will make that and just the last point to try to respond to your concern is that, again, there is the potential for that. And the reason why there is the potential is that when a company is looking at a state with 3-factor formula versus a single sales factor formula, there is less of a tax cost to moving into the state with a single sales factor. Without any further questions on single sales factor, I'll move to throwback. Throwback, just from a tax policy standpoint, aligns very well with single sales factor. It's consistent as well as market-based sourcing because it, again, looks to the market and not the factors of production. So in that sense, having a tax reform bill that has both single sales factor as well as the repeal of the throwback rule is very consistent. I did put some comments into my outline, which you can see that generally speaking, throwback does penalize in-state companies. When you think about the burden, it impacts a lot of smaller companies more than larger companies because the smaller companies just simply don't have the footprint that a multi-state or multinational company does. Many multi-state companies have nexus in every single state, which means there is no throwback. So there might be a more disproportionate, at least on a theoretical level, and I don't have any data, with respect to throwback hitting smaller companies a little bit more. The proponents of throwback, just to give you a balanced view, tend to take the position that 100% of the income should be taxed. And I would just offer a countervailing view that sound tax policy supports more of a consistent approach that looks more to where income is earned and not with respect to whether or not a company is subject to tax in another state. Those are all my comments that I'd like to put forward on the repeal of the throwback rule.
Okay. Any questions on that? Okay, I think we can keep going.
Okay, so we have 3 sections left, and I really have comments on one, and then from a tax policy perspective, I don't really have strong opinions on the other 2, but I'm happy to go through those and answer any questions that you may have. The comments that I really wanted to address are in subsection B of the outline, which relates to the increase in the minimum tax amounts. My observation is that there are some significant increases, particularly in the top range level, and those would be companies that have over 300 million of gross receipts. And there are only, a handful of states that I'm aware of that have that level of a flat tax in the country. My concern with Vermont enacting the numbers that I'm seeing before me is that a couple things. One, it has the potential to be punitive for not only loss companies, because they don't have the profit at the time that they are being imposed with the tax that is flat, and also on startup companies. Right? And startup companies typically take a number of years to become profitable. So they're in the same situation that a loss company is, in being potentially subject to a flat tax without having the corresponding profit. My other concern that I've put in here is that the flat tax based upon gross receipts is very arbitrary. It is placed on a company without regard to the value that is added. And I think there might be, although I do not know, which is why I put a question as to whether or not there is a constitutional issue with the levels that are being proposed. But my concern is whether or not you might be in a situation where you have an out-of-state company who is making sales into the state, but has no presence in the state of Vermont and being subject to, at the high level, $100,000 flat tax, and whether or not that would be fairly related to the services provided by the state. And those are sort of the, some of the standards that are put forth under the U.S. Commerce Clause. So I will just express, I have some concern about the amounts that are being proposed on the minimum tax.
Okay. And you think that might run afoul of the Commerce Clause? That's something we have not had testimony on, so we should take a look at that.
Yeah, and Senator Cummings, I just want to be very clear in my comments. Obviously I have not had a chance to analyze it,
Right.
and I am not asserting that there is a Commerce Clause violation.
Right.
But if I were approached by a company that had no offices or employees in Vermont, but that was slapped with $100,000 minimum tax, that would be one of my first inquiries, is whether or not it doesn't
Okay.
fairly represent the activities in the state.
So we should just take a look at that. All right.
I would, if you don't, that would be my recommendation. And the last two sections, and I'll jump to subsection E in the outline, which is the shift from Joyce to Finnegan. As the first one, I don't have any strong policy considerations for you all on that. The only thing I'll offer is, the states are about evenly split between Joyce and Finnegan. So it's really a decision by the state as to which method you want to go with. There obviously will be an increase in tax for inbound sales of out-of-state members that have no nexus, because those sales will be included in the numerator. So you obviously would see tax revenues increase and a tax liability on those companies. To the extent throwback is retained, I think the issue there is that outbound sales would not be subject to throwback. So you would see a decrease in sales from in-state companies. So I guess my only point there is that, to the extent Finnegan is the choice for this committee recommendation, that the repeal of throwback also be retained.
Okay.
And the last section I'll address is the repeal of the overseas business organization provisions.
Mhm.
And really, what Senate Bill 53 is proposing to do is to include all domestics in the combined group, regardless of the 80-20 test. And the bill is essentially proposing to take you from one system of taxing foreign income to another system of taxing foreign income. And one of the things that I mentioned to Senator Pearson before, in comparing New Hampshire to Massachusetts, for example, is that Vermont and New Hampshire have some of the most aggressive methods of taxing foreign dividends right now. We tax the foreign dividend when it comes back, times an apportionment factor. The bill proposes to instead take the domestic entity put it in the domestic group so that the income is taxed over the domestic apportionment factor. So you lose the foreign dividend and the taxation of that, and you put it in the domestic group. And I don't have any strong opinions on that shift, other than to indicate that it does just tax foreign income in a different way than Vermont is already taxing it. But I'm happy to answer any questions on that.
Okay, committee. Any questions? I think if you're finished, we can probably take that down. And I'm making notes. Okay, committee questions at this point. I am not seeing any. Okay. All right. So thank you, Ms. Michaels. I think this has been helpful. It's been helpful to see it all laid out in outline form.
I certainly appreciate the opportunity to be before you all, and I think that it's really great to see Vermont looking at tax reform, looking at being consistent and modern with some of the trends that are going across not only New England, but the country. So I commend you all for having these conversations.
Okay. Thank you.
Thank you.
We'll see you. And committee. We've got Abby is here. I think. Yep, there she popped up. Abby, do you have your section by section you can put up and we can go through? I would either like to decide we're not going to do this or we're going to do something that will get us into conference. Because we are getting closer and closer. We're halfway through February. So I have asked about S53 and crossover, and I have not heard back from Secretary Bloomer. I will drop him another note asking him for that, but I don't think we're going to know more in 4 weeks than we're going to know in 2 weeks. So I think, I'd like to start going through and see if we can find out where the points of agreement and the points of disagreement are. Okay, Abby, let's walk through it.
Great. So for the record, Abby Shepherd, Office of Legislative Counsel, I'll share my screen. Faith has posted this under my name as the section by section summary. Can everyone see the document? I'm sorry. I don't know if there's something wrong with my sound.
Well, our last witness had trouble too.
Huh. Oh, it says my screen sharing is paused. Let me try resume share. Is that working now?
It says, yeah, there it goes. It is up now. Okay.
It's the first time I've seen that. Okay, so this is the House proposal of amendment. Do you want me to just look at the corporate changes or everything that's in the bill?
Wait. Section 1. All right. That's already been passed. So that's
right.
Yeah. Okay. So sections 1 and 2 have been taken off. So we can start with the corporate income tax. And can we agree to delete sections 1 and 2? All right.
Madam Chair, you had also discussed using those sections as sort of a placeholder for making the definition name
That's right,
change.
changing the definition. Yeah. So I think we've decided to do that. So that would be good to add there.
Okay. I do have draft language based on the letter that was sent to Streamline last year. So I have that prepared.
Okay. So we will add that there.
Great.
This is good. Okay. Minimum.
Section 3 repeals the definition. So as you just heard, it does change overseas business organizations. So for a refresher, those are US incorporated corporations who have 80% or more of their property and payroll outside of the US. So that would then include, this change strikes those definitions. So it would include those corporations' income in the apportionment factors.
Okay. Committee. Discussion on this section. This is the first time we haven't really heard how we tax them now. I think the previous witness is the first time I've heard that we are very aggressive. Do we want to get a little background on this? Yes, no? I'm not, does anyone
Yeah.
care? All right, we will ask joint fiscal or maybe Abby to just give us a little background on how we do corporate taxes now. Does anyone have any other concerns with this section?
What section are we talking about? Number
This is
3?
the 80/20. It's section 3.
So I've just been thinking, I mean, I understand all the individual sections. I think I've said this before. I think about this as a package, and I'm
Yep.
fine with the package. And I feel like we're having the same conversation over and over again, and it's a little frustrating. So I don't want to hear more testimony. The testimony we
Okay.
just got was really unhelpful, and actually I just want to move forward and look at the other sections in the bill and decide whether we're going to pass this bill or not. I think the corporate tax stuff we've kind of beaten to the ground at this point.
Okay,
Agreed.
who was that? Senator McDonald?
Yes.
Okay. All right, so we've got 2 that just want this over with. I'm trying to hear from other people. Okay, the corporate,
Madam Chair,
yeah,
I'm not going to make this neater, unfortunately, but to me that no part of this bill is deeply important to me, but there's a lot of little give and take elements here. And for instance, if we don't do single sales, then I don't see any reason to do the change to corporate minimum, and so that's where it's just kind of difficult to answer your questions chronologically because of the
Okay.
interplay.
well, let's
so
go
I'm-
on to
I'm-
single sales then. And maybe Abby can take that down and we can have a discussion on single sales. This is a package. They
But it
gave,
doesn't, I mean, the House made it a package, but.
yes, it does not have to be.
Mhm.
But it does, they gave something in single sales to some businesses and they took something to other businesses, and those businesses can migrate depending on the year to either one of those sections. So they went to single sales, and the argument was that it took us along with the trend, along with the Joyce to Finnegan, and helped us follow where most states seem to be going at this point. And it put us in with market-based sourcing, right? That we did several years ago. And it would help. No data available because companies don't publish it, but it would theoretically help put more of the tax burden on companies that do not have a presence in the state of Vermont, because we would not be figuring in their employees, their factory, their office, their retail store, or warehouse when we figured it. I think that's, and then that was counterbalanced with an increase in the minimum tax. And am I right, Abby, that 90-some%, it's a vast majority pay? Graham has come to keep us honest. What's a vast majority, Graham, that pay the minimum tax?
About 70, for the record, Graham Campbell from the Joint Fiscal Office, it's about 75 to 80% of corporations that
Okay.
file corporate tax returns pay the minimum tax.
Okay, where'd I get 93? It's from somewhere else, I'm sure, but
So I think what you're getting that one from is most corporations are very small, so under $100,000 in gross receipts, and about 90% of those corporations pay the minimum tax.
yeah, that may be where I'm getting it. Okay. So our smaller startup businesses, the argument is that for a smaller startup business or for a business with a loss, I think that was our previous witnesses. Testimony that might be seen as punitive, but that's going to be punitive, I think, regardless.
Madam Chair, just to refresh the committee's memory, for the smallest corporations that are paying the minimum tax, they would receive a actual reduction in their corporate minimum tax. So for those under 100,000 would receive a 50% reduction in their corporate minimum tax. I think the previous witness was sort of speaking about, gross receipts tax in general. There are corporations that, particularly startups are an example, where they will, have gross receipts, but because they're a startup and they're reinvesting profits and spending a lot of money to get going, they don't have net income. And so they're more likely to have, zero net income or losses for tax purposes. And so to the extent that the minimum tax is what they would likely be paying, a higher minimum tax would result in higher tax liability for them.
Okay. So committee, single sales factor, Senator Pearson.
Graham, could you remind us your chart that tells us the costs and ups and downs of this? Single sales factor costs us $11 million next year.
Well,
but it's hard to predict. Can you just give us a snapshot again, please?
Yeah, so I did have Faith send or post the estimates that I've done. But single sales factor, we project will reduce general fund corporate tax revenues by $11.24 million in fiscal year 23, but in year one, I should say. So it's unclear. This committee has not changed the effective dates that are in the bill. And so if this committee were to make the effective dates, say, effective for January 2022, it would probably have an impact close to $11 million. But if you made the impact January of 2023, similar to how the House did it, then it would be sort of a number that is a little bit more than half of 11.24, because of just the way that corporations make their payments of taxes.
So setting aside the timing question, when the House passed this, they thought it cost $20 million. You've updated, gotten more precise, and it's $11 million. It's hard to predict, but is there a break even? In 5 years, we would think it would not cost us anything, or I mean, I guess, Madam Chair, maybe I'll just cut to it. I would propose we not include single sales factor. I don't see any reason on earth why we would give big corporations an $11 million tax break.
I guess to the question, no, relative to current law, this is a reduction in revenue. So we are not counting additional revenues from the change to single sales factor in the out years. It's roughly $11.5 million over the next 4 years, as we predict.
Okay. Committee. What are your feelings on the single sales factor? can we do a thumbs up, thumbs down?
I'm not interested in losing the revenues.
Okay, but you're making it up. Remember, the overall package, we're going to gain 1 million.
The first time we gained on corporate taxes in a long time.
Okay, and no one's buying the,
That's not a striking
no,
meteor-like
it's not.
gain by any measure. Every time we change corporate taxes, we're told it's going to be a benefit, and then we get another corporate tax change that gives away more.
Okay, so you're going, to
Not at this point entirely sold on the benefit. And I'm not sure if there's anything more that we could hear that would constitute clear reasons as to why we should do it. I realize that that's what the trend is. And what I'm really trying to understand, if the trend is in this direction, but it would harm us, which is what I'm hearing, there's something missing in the explanation that I haven't caught yet.
okay,
Oh, in fairness, Madam Chair, it has been expressed that this is a package, in some parts gain and some parts lose.
mhm.
So I'm not happy about the parts that lose. The question is, do we accept the package, or do we go through and have some votes to pare away at parts of the package and see what's left? But that's,
Okay,
Well, I'd like to understand, though, if we pare away, what the potential impact is overall. I'd also like to understand, would we be the only state that have chopped away at pieces of what seems like an overall trend? And what are the downsides of doing that?
okay, I think we have heard that we are the only New England state and New York that has not gone to the single sales factor. So that does make us an outlier. We would be the only one of our neighboring states that would be factoring in the value of your factory and payroll in the state in apportioning your income.
so
The argument
Chair,
is,
I agree with what Ruth said. We have a package. What Senator Hardy said, we have a package, and we can vote on that, or we can, I guess, listen to people make amendments to alter it, or we can accept the package, and I'm ready to go.
well, whenever anybody's ready to accept the package, they can make a motion. I haven't gotten the feeling we're ready to accept the package, but I also am not sure we're ready to reject the package.
Madam Chair,
Yes,
I've tried to put a proposal on the table, but I'll flesh it out a little bit. We've agreed to add language, so this would be an amendment, I guess, but
okay,
in concept, we're adding language around menstrual products and getting rid of the other section. I'm proposing that we get rid of the single sales factor in the bill, and we get rid of the change corporate minimum. And then the others sort of get close to balancing out, is my memory, but
so we'll keep Finnegan to Joyce.
yes, I think that makes sense. And then the other ones were small changes.
Well, there's the 80-20. We'll do that. And we will, throwback.
Except for unless we do the single sales factor, it doesn't make sense to do the throwbacks, because those two actually do pair together. So if you're not going to do single sales, then don't do the throwback. And then if you just do the 80-20 and Finnegan, Joyce to Finnegan, then we're up tax revenue, which I'm totally fine with. Like, don't get me wrong, I'm totally fine with that. If
It's going
you
to
want do
conference,
just
so,
just those two things. But if we're gonna do single sales, we have to do corporate minimum. If we're gonna do corporate minimum, we should do the single sales. Those go together, but that would be an up of about almost 10 million.
Okay, so what I'm hearing, and I haven't heard anyone say no, is we'll keep the menstrual language. We're going to, no single sales factor, so that's out. No corporate minimum changes, that's out. We will keep Finnegan to Joyce. We will keep the 80-20 rule. We'll keep the throwback. This throwback is, we have now.
Well, Senator Hardy made a good point about there is a logical pairing, right? Senator Hardy, could you say that again?
Yeah, I think what the chair means that we would not repeal it. Is that what you mean, Madam Chair?
Not
The bill repeals the
throwback rule.
So,
And I think the testimony was if we did Finnegan to Joyce,
no, it goes with the single sales factor.
okay, this is
Or,
yours.
Abby,
Okay, so we would not,
Graham,
yeah,
can
I've got
you
keep
confirm that?
throwback. We would not repeal the throwback.
Or does it go with Joyce to Finnegan? You clarify.
Yeah, sorry. The throwback rule and the Joyce to Finnegan, they're not paired, but if you move to Joyce to Finnegan, the impact of throwback is, very minimal.
Okay, my mistake, Madam Chair, you were correct.
I think one of this tax department said it would hardly be, cover the cost of administering it. So do we want to repeal, if we do Finnegan to Joyce, do we want to repeal the throwback? Okay, so we're going to repeal throwback. Abby, what am I'm on Graham, so I'm gonna get back to yours section by section. What do we have left?
So this ends, I'm sorry, but I'm just looking at Graham's chart. This does, as Senator Hardy said, leave us with about $12 million up. Right. Oh, excuse me. No, with about $8 million, $9.5 million. Yeah, no, $9 million. So is that right, Graham?
That's right. That's right, Senator. It's if you strip out the corporate minimum and the single sales factor, then this bill would raise revenues by about $8.9 million in fiscal year 23. Again, pending what you all decide for the effective dates on those provisions.
So I'd like us to think of some creative way to spend that money in a tax incentive or something. Maybe Senator Sorokin could help us. That pushes businesses in a good direction and tries to get us closer to zero. I mean, I think we owe the House some version of this bill, and I think we should try to keep the balance pretty close to zero. If there's a policy we can land on.
We can take up the cloud tax.
Well, no, that raises us money.
I know, but the House would like the cloud tax.
Well, I'm not so interested in that. I'm trying to suggest that we not get ourselves in trouble by looking to raise money, but that we kind of give a counter proposal that gets pretty close to zero, which is, what the House.
Well, I'm going to leave that to you to think about, because we have had no suggestion of that. And that really would be more of in Senator Sorokin's territory. But I'm going to ask Abby to draft up mostly with, can you do the Zorro marks like they do in the House? Mostly draft up what we've got and we can vote this out. The other sections of this bill is the military retirement income and Oh, and the Department of Financial Regulation fees.
Madam Chair, may I just
Yes.
ask, as Graham had mentioned, that the effective dates were also linked to the corporate income tax changes. If I'm drafting those changes to the corporate income tax, it'd be helpful to know if you want to push it out a further year or keep the dates as they are. Either way, that needs new language. because
Yeah,
they're
it
not
doesn't,
trustee
we don't
retroactive.
usually start retroactive taxes. Right, in
Such a large
January
change.
22, so I
Mhm.
would think it needs to go out a year. All right. Okay, so that means we won't get any revenue until next year, when we may need it more. All right,
Sorry, you would get some revenue because if you make it effective January 2023, corporations will make some estimated payments between January
Okay.
and July. So some revenue, I think it's less than half or so, but you would get some because there's still payments being made.
okay.
A wash over time.
Abby, can you walk us through what the DFR fees?
Sure, so those
That
fees-
has not, all right,
You have seen this, I think, very briefly. This I can pull, actually, it might be easier to see the language itself. Would you like me to share my
yes,
screen?
that would be fine.
I think that actually, it's a very short section.
I just got a pop-up news. Secretary of State Condos is going to be retiring. So it just popped up on my screen. I knew that was under consideration. Okay. So if you can show us, Abby.
Sorry, I'm just pulling up the language. Okay, did that work that time? Under
Yes.
fees, great. Okay, so this relates to investment companies. They pay two fees currently. There's an initial notice filing fee that goes to Commissioner of Financial Regulation. That's the commissioner referred to in this section. You'll see it's not in Title 32. This is Title 9. So there's an initial notice filing fee of $2,000 and then an annual renewal fee of $1,500. And it's the annual renewal fee that's being increased to $1,750. And that's for each portfolio or class of investment company securities. My understanding is that this was part of the package again to equalize out the revenues, and that most companies that are paying these in all 50 states, these sort of fees. And then I know in terms of comparisons to other states, I believe Graham has worked on that. If you have questions about what Vermont looks like compared to other states.
Okay, Graham, can you tell us what Vermont looks like?
Sure. So as Abby said, this raises the renewal fee to $1,750, and that would be, at least as of last year, the highest in the country, tied with Rhode Island. Rhode Island has a very high fee for this. And so typically what you see is smaller states setting this fee higher because with these financial institutions who are were in this space, they have to register in basically every state. And so for a large state, this really does not impact their revenue impacts the revenues, but it's so small relative to their total budget. But in small states, this can lead to a substantial amount of revenue. And so the smaller states tend to set higher fees for these types of things. And so as of last year, I think testimony from the commissioner of the Department of Financial Regulation said that this would put Vermont at the top with Rhode Island, but not higher.
Okay. Did DFR request this, or was this added as DFR didn't request it? Okay, this was just a way of raising money.
That's correct.
All right, well, I would suggest that this is a fee. We will get a miscellaneous tax bill. If we don't need to raise money, I don't know why we would raise that fee, but anybody that wants to, let me know. Just if we decide later, we will have a bill to attach it to. But, okay, I think I'm not seeing anyone objecting, so strike it, Abby. Okay, all right. So Abby, if you can draft that, I'd like to send this as clean as possible. We do, and we need to put in the section about changing the name. Good.
There is also two other sections that are in the language that relate to an income tax exemption that is on your schedule to be discussed on
The
Friday.
military, yes.
Military
tax,
retirement
yeah.
income. That's correct.
Yeah.
I don't know if
And
you wanna
we
consider
have a
that.
bill, well, we have a bill to do that, and we have a bill on civil service.
Yes, the civil service
employees,
retirement system.
And I know the House has sent us a small increase in the amount we exempt for Social Security. My goal would be to put them all on an equal plane, that some pensions are in lieu of, mostly federal, but I think there's some large municipal pensions dating back to the beginning of Social Security that are paid in lieu of Social Security. I have a feeling a couple years ago, the railroad employees were in, and I'm not sure how to find them. I think they may find us, but they may well be another group that didn't pay Social Security, so they don't get Social Security payments, so they should at least get exempt what we exempt for Social Security is my.
I believe they already do, Madam Chair. Because it's preempted by federal law. I believe Vermont already exempts railroad retirement.
Oh, okay. So railroad is preempted, but civil service and military are not. The glories of the feds. All right, the railroads had a good lobbyist. Okay, I don't know why they were, but they were here. Last time we talked about it, there were several of them that were here. Okay, so that's, we're going to start taking testimony on that this week. And now I have once again lost my, or have I lost my, yes, I have. Let me see.
Madam Chair, for the
Yeah.
amendment language, would you like me to leave the DFR fee and the military retirement income exemption in?
No,
Or take it out?
no one said they wanted to do that fee, and since DFR didn't ask for it, and we will have a military bill, I think we can let that one go.
Okay.
And military pensions and others we're going to deal with. We've got enough vehicles to deal with those with that, because they aren't really related to this bill. This was just like whatever we haven't dealt with somewhere else, we're going to throw in here. If I could find another way to change the feminine hygiene products language, I'd take that out of here too. But I think we should change the language and the title. And maybe you could put the feminine hygiene at the bottom.
Yes, I'm going to draft it as a strike all, so it will be a little
Okay.
cleaner. So you'll see this is what you're proposing to have in the bill. So it'll
Because
all be-
anyone that looks at our agenda is going to think we have been spending a whole lot of time on feminine hygiene products. And I expect to get lambasted somewhere in social media for that. So, okay. I think we're set on that one. And I thought we might actually get a break, but we aren't, because we're going to the next fun program, which is timeshares. And Abby, you're staying, lucky you're staying with us for this one. Tom Vickery is here. I asked what we did, there was a mention made by the timeshare people of Bruce Listman and changes that happened, and they had to have board of directors, and I went looking for it, and all we can find is the 2014 change to the condo codes, which I had the joy of presenting on the floor. And it was it was the Universal Commercial Code, a UCC. Bruce Listman is our representative on the National UCC board, and you are either in compliance or not with the UCC. So we did not have an in-house drafter on that one. But I couldn't find anything, and David Hall just said it was all on condos, and nothing that I could find had any real impact on the present situation. But Mr. Vickery.
Yes.
We have taken lots of testimony, which I guess has added clarity to say that this is a property, a class of properties that at the present moment is neither fish nor fowl. Part of these are still your traditional timeshare condos that have basically no market value. But these timeshare condos are being bought out very rapidly by a business. I'm assuming once it's a business, you will be able to do an income-based. They're buying them very cheaply, so you can't do a market base, right, on these properties. And just help us figure out, is there light at the end of this tunnel if we can figure a way to get through?
I'm trying to get in touch with California because can I speak?
Okay, we're having a hard time hearing you.
Can you hear me now?
Yeah, a little better now.
I'm trying to get in touch with California. You had PV&R come up and say that they were appraising them similar to what we're doing it. And I have a different interpretation of that, but I have not been able to prove it yet. So I'm not going to give it to you.
Okay.
Traditionally, we've been always taxing them as timeshare to the timeshare estate owner. So we've been taking the sum of the parts and coming up with a value.
Right.
Right now, if we do a sum of the parts of the timeshare owners, we're going to have no value. And that's what the MAI appraiser did on the appeal. He basically was saying that a 1,700 square foot, 3-bedroom condominium had a value of about $66,000. When we're valuing around $300,000. You had, I gave you a sheet that explains some of the perspectives on how these condominiums are appraised. And right now we're really appraising from an ownership standpoint, not looking at the unit itself. And that's why we're saying we should probably be looking at the unit as a value, not as the ownership of it, because the ownership is very cloudy right now. We have timeshare estates, and some people like them, some people don't like them. The one that don't like them are giving them away. We have equi-shares, we have family shares, we have Club Wyndham owning, in some cases, over 50% of the projects, of some of the projects. And as time goes on, they're going to keep owning more and more of those projects because people are.
2 buildings.
Pardon?
There were 2 or 4 buildings that Wyndham owned completely. How are you praising those?
I gave you a chart that I asked Faith to look at, and I show you where the Club Wyndham's projects are and also Smuggler's projects in the same type of building, and I show you what the values are. And if you look at Owls 2, we have those
Okay,
in.
I've got, yeah, it is up. Wyndham values. All right.
And what I did was I put down what the 2016 value was and also what the 2017 value was on the reappraisal. And if you go through that and look at that, you're going to see some going up and some going down. Going to the whole methodology way of appraising did not mean that all the values went up on these condominium timeshares. Some did go down. And if you look at the Tamaracks, those values that were established in 2017, if you look at Owls 3, and when we appraise a condominium, we're looking at the condition of the condominium, we're looking at the quality of the condominium, we're looking at the type of unit it is, whether it's a 1-bedroom, 2-bedroom, 3-bedroom. We're looking at the location and the amenities that go along with that condominium and put values on them. And those values will vary depending on the condominium itself. So you see on Owls 3, which is their presidential suite, which is, you go into that and they're just really well built. You have 9-foot doors going into the unit itself, very well furnished. That value increased, but you see Owls 2 decreased and Tamaracks went up. Tamarack 6 went up, which was also in that area where the presidentials are. And Kestrel's 2 went down. And you'll notice that if you go into the Smugglers project, we value the Kestrel's 2 the same as we did Kestrel's 1 and 2 as $2,070,000. And they went down a little bit in valuation. So we're looking at them as a whole unit and trying to find some semblance of order in the valuation methodology. What I've done, you'll see no change at all that was made on Club Wyndham. They did appeal twice since the 2016. They were denied by the town. They did not take them further. On the Smugglers projects, on the other hand, those were appealed further, and you see the reduction in the 2020 value. And they went down in value. The first one, Owls 1, which is in a good location, didn't go down so much because that was a family share unit. The other ones went down quite a bit. So we have a lot of variation in ownership on these units owned by the different parties, whether it's Club Wyndham or timeshare estate owners or family share or equal share. And we value the ownership, we end up with quite a bit of difference in value for a unit. And the unit is the same quality, no matter whether it's owned by an equal share, a timeshare estate, or by Club Wyndham, depending on the quality of the unit. So what I tried to do too, if you look on the other sheet that I gave you some perspectives. And one of the perspectives is that the property tax is the killer on of the people trying to get out of the property. And I gave you an example that the property tax on the 3-bedroom condominium is roughly $6,500 or $7,000. The management fees, which include the property tax, are between $55,000 and $60,000. So it's not a big portion. The property tax is not a big portion of the management fee. And it's the management fee is why these people are leaving their projects when they are tired of owning them and they don't want to use them anymore. And that's why people are leaving on the timeshare estates. I don't know what the answer is. I do know that if we appraise them the way the appellants wanted us to appraise them, it's a liquidation value. It's not a fair market value. And I wish I had an answer on how to do it. The town tried to have a MAI appraiser too, to appraise it, and an attorney to.
What is an MAI appraisal?
That's a designated appraiser with a real estate appraisal institute. And that's your top appraisal. They usually do commercial properties. And are designated to do that. Most assessors do not have that qualification.
Okay.
But he was not able to give us an answer on how to appraise these condominiums. And The other appraiser for the appellants just did a market approach on the liquidation sales and said that is the value for the timeshare estates. And I don't think that is a fair value.
Okay,
I don't have an answer for you. I am going to try to get what California, my understanding that California was allowing the assessors to do it on a whole unit basis. PV&R said no to that. And I have not been able to get an answer. If I get an answer, I'll get it to you.
okay. So, well, we don't know. Club Wyndham did not appeal. You assessed their, you assessed their
Club-
property.
Club
They
Wyndham
didn't appeal, and so in 2020, there was no change. That's the buildings they own.
Yes, and they did appeal for two times and during that time period. Both
Okay,
times they're denied their appeal.
okay. But they did, all right, but the issue is the buildings that are left that are, in some of them have traditional timeshare folks in them. Some of them, it sounds like Wyndham has bought out some of the units. So, but they're buying them out at the pace. Yeah, they're buying them out at the fire sale prices because, yeah, we've heard $2,000 a month that people didn't want to pay. So yeah, that's gets to about 55,000 a year. And that's, so they're walking away rather than pay that, and they're selling it for pennies on the dollar. And Wyndham is buying them up. So your sale value, your market value is probably artificially low. Once Wyndham buys it, they don't sell, they rent. But then you're back to the building, I guess. It's what you're.
Understand that if we tried to get a higher value on the Wyndham parcels, that value is going to be distributed among all the owners, whether they're Wyndham owners or timeshare
right.
estate owners.
So we're
There's no-
raising the property taxes on the folks
We have
that
no,
still go.
yeah, the way the association's bill is it's on an average billing cycle to each owner of the timeshare estate, whether it's a one bedroom or three bedroom. They'll vary it on that basis. But they don't just differentiate between a Christmas week or a President's week or a July 4th week. They're paying the same as the float weeks are paying. And I think that's why people got very upset with the management fees, and they had no control over it. I think you had Jim Mazur come in and testify before you. He was part of an equal share or family share condominium. They left Smug's management and formed their own management company and were able to lower their management fees to some degree and take over the control of it by going to a different management that takes care of the condominiums. The timeshare estate owners didn't have the flexibility that the equal share or family share had because it was too many owners, and they don't have control of how it's being done in the association for the distribution of the management fees. And that's where the big rub is. And I don't know, I don't see how we can divide the value between what Club Wyndham owns and what the timeshare owns and come up with a mixed value and then have that distributed properly, because the association entity controls how the different weeks are going to be paying. That's why we made the decision to go to a whole unit, to basically say they're being used the same no matter whether Club Wyndham owns them, or the timeshare estate owns them, or the equal share owns them, or even if a whole owner owns them. The perspective is, if I'm a whole owner at Smugs, it's a vacation property, I'm using that property, I may only go there a couple of weeks of the whole year. I may try to rent it some other years. It's my vacation property and I'm not living in it. And that's the concept of where the timeshare concept came in, is that you go and you rent it for a week, you'd be having a vacation for a week. And Club Wyndham has taken that a step further. You aren't buying into the project, you're buying the vacation. And I have no idea what Club Wyndham charges for their vacations. So
No.
I
Okay, so you're
Assessor-
looking at
as
the
an assessor,
condition,
we'd like to have more clarity on how we're to appraise these timeshare projects. And right now, the clarity is not there.
no. Okay, committee. Thoughts, questions, Senator Pearson?
Well, I don't need to go first, Madam Chair. I've been. mouthing.
You're the only hand I saw, so.
Is this thing on? Tap, tap, tap. It's strike. I mean, we pay taxes to support schools and towns, and what machinations go on behind the door is completely irrelevant. It would seem to me. We have this sort of delineation. So I'm not sure exactly what to offer, but I hope we will figure this out. And I think it's timely and important, and a question of tax equity for the towns that are getting hit with what is essentially a creative corporate game in a way that. So I hope we can do something. I'm not convinced the bill is as drafted is right, but it just can't be that complicated.
I think to answer your question, with the timeshare, the way we're doing them right now, we're really appraising the ownership, not the unit. And I think we have to get back that we're looking at the unit value. And the law says we're going to put a value on the unit, not on the ownership. And the ownership is what is clouding this picture. I don't have to, if I go out and appraise a house in the town, I don't look at the owner. I look at the house. In this case right here, I'm looking at the type of ownership for the condominium. And I think that's a cloud on the valuation process.
Okay, Senator Bray and then Senator McDonald.
Thank you, Madam Chair. So I think I probably share what sounds like Senator Pearson's concern / frustration, or everyone's really in a way. It does feel like the state is, the legal construct is kind of gaming the appraisal process in a way. However, intentionally or not, in the end, that's the net result. So we talked 2 weeks ago, maybe, about 3 ways of appraising, just a straightforward property appraisal, replacement value, or earnings related to the property. And so lots more about this, but I'm just wondering, do we have an option that we've considered, like moving to replacement value as opposed to the ownership piece that you were just pointing out, and saying, okay, that's how, if we applied that, it would sort out sort of the legal machinations that are making it so challenging at the moment. I'm just wondering if one of the alternate fundamental techniques of appraising gets us out of this rut or not.
I think the bill calls for one, right? It calls for the unit valuation.
It does. I mean, you cannot change the concept of fair market value. And the bill specifically says that we're to appraise the unit, not the ownership of the unit. And I think that cloud has been made with the ownership of the unit and the variations that we can get on how that is owned. You can use an income approach, you can use a cost approach, you can use a market approach, and traditionally condominiums are appraised by a market approach. I tried to get the appraiser the town hired to look at it from an income and cost approach, a replacement cost approach, just to get in there the fact that these are really in good shape. They're fairly new condominiums. They've been well maintained, and the value is not $66,000. It should be higher than that.
Right.
And that appraiser, that MAI appraiser, could not get to that step, because traditionally, when we look at a condominium, we're appraising it from a market standpoint, not from a replacement cost standpoint, and not from an income standpoint. A lot of times, the people that are buying these timeshare estates are looking at allaying some of their costs that they could rent the units or rent a floating week to cut down their cost. And they found that the rental market is just not there now. And so they've lost that part of what they probably thought they were buying when they bought the timeshare estate. Most
Sure.
of them wanted it the first week. They did not want the floating week, but the
Right.
floating week was put in there.
Okay, so
Well,
what,
can I ask one
Yeah.
follow-up, please? But if I bought a home and my neighborhood sort of went downhill over time, I could conceivably lose value in that home. It's a risk that goes along with owning property. You don't really know how it will ultimately be valued. You'd like to think it will gain over time, but I don't know why these folks are somehow isolated from this, but while my property is depreciating because the neighborhood's going downhill, I still have my property tax bill. Now, maybe it gets adjusted down over time, who knows? But this feels like exempting themselves from a business decision. They're using that to exempt themselves from the property tax in a more traditional sense. So I'm sure I'm going to be beat 10 ways to Sunday by the lawyers on this, but I just don't understand from a neighbor to neighbor point of view, why you wouldn't say we all chip in. You can't reduce the value that way.
I have seen timeshare condominium projects that have lost all value because the people have walked away from them, and the depreciation on those projects have gone way downhill because they weren't well established to begin with.
Mhm.
Smuggler's Notch is a well-developed resort community for the condominiums. Stowe has that. Again, the question is, what are we appraising? Are we appraising the ownership or are we appraising the unit? And that's what we're trying to get at. And
Okay.
try to come up with a measure that the assessors can use in the state.
Thank you.
but isn't the appraisal of the unit based somewhat on the resale value? You look at similar houses and sales of similar houses or units. And what's really gone on this is not the market value of the building. If you just took the building and looked at it, it is the market value of the ownership form that is gone. No one wants to buy this ownership form.
I gave you some examples in Village Green, and I also gave you the example in Kestrel's in Smugs, where those were timeshare estate condominiums and were turned over, voted out, so they could be sold as whole unit condominiums. It can be done, but it may take 75 to 80% of the people involved in the association to say it's okay to sell it as a whole condominium. That's a pretty high mark to get, especially when you have Club Wyndham owning probably a bigger percentage now of most of those projects.
Yeah.
And that's not going to happen.
No, I think the testimony was that, yeah, it's not going to happen, that they just haven't got that vote. Okay,
Well,
so,
it could happen if Club Wyndham wanted to sell them as whole condominiums.
Right.
But it's going to be Club Wyndham making that decision, or Smugs making that decision, which they did with Kestrel's, or Village Green making that decision, and the units in Village Green in Stowe.
okay. Senator McDonald.
Madam Chair, I've been around the barn a few times on what the problem is. The courts ruled there was an appraisal that was attempted, which seemed to have some common sense to it, and the court rejected it because it was not permitted by the law. So we need to change the law to make a common sense appraisal system permissible. Are there any other states that have dealt with this that can give us an example that we could copy and or modify to work in our here in the state of Vermont?
I'm checking with California. I gave you an example in the first information I sent out to you of what I saw was Rule 998 in California that allowed an assessor to appraise them as a whole unit condominium without regard to timeshare estates. BVNR came in and said that that's not the way it was. I'm trying to check on that. I
Okay,
think other states are having the same problem we are and are trying to deal with it. I don't know how, I can't give you an answer yet.
Madam Chair,
Yes.
the way that the appraisal was made that was rejected by the courts for not being authorized by Vermont law might be worth learning, if only because we might choose to authorize it by Vermont law. But we need a starting point for
To
a
work
written
on it.
solution. So
Just, Tom, did this go to court? I understood it was a settlement.
In Smugglers, it was a settlement. It wasn't, did not go to court. Nobody wanted it to go to court because nobody could prove a value. In the Ludlow case, which I think Senator McDonald's talking about, that was not a value on the condominium. That was a value on the common elements that
Right.
went with the condominium. And that the condominium law is very clear that we are not to appraise the common elements. And that was the decision in the Ludlow case. All right,
Okay.
it wasn't on the value of the condominium itself.
And it wasn't a timeshare. It was
It
basically.
was a timeshare.
It
and we're
was,
trying
but,
to-
okay, but
And
we're
they're
gonna
trying to-
add the value of your pool membership and your ski membership. And that's all going to get figured in along with the building value.
I think
And
what
that gets struck down, but that's not what we're talking about here.
I think
Madam
what,
Chair,
I think
the-
what.
Yes, Senator McDonald.
what was struck down in Ludlow wasn't struck down because it was a good idea or a bad idea. It was struck down because it wasn't lawful. Perhaps we could look and see what was struck down and make it lawful.
Okay, we'll ask Abby. But I don't think what was struck down as unlawful in Ludlow is what we're being asked to do other places.
Don't disagree. If someone has a better starting point.
Okay, so
propose it,
maybe
but
we can
that's
ask
the only
Abby, or
one
it
that I
might be
see
David
available.
Hall, because I think that might come under that UCC condominium regulation. So we'll see if we can trace that down. Okay, Senator Abby, you popped up. Do you have something to help?
That would be me. I can review the case and come back. I have read the case, but I had not prepared that for today.
Yeah.
My understanding, as Mr. Vickery did just say, is it was primarily about the common elements. But I can go back and look at it from that perspective and give you a summary. But I would
Okay.
request just a little bit of time to prepare that for you.
Okay, no, I'm definitely going to give you time to prepare that. Okay. We don't want a legal opinion off the cuff here. Okay. Senator Pearson, and then I think I saw Senator Sirotkin.
Well, just to say, we also we're hoping, I think, to address the timing issue that the town confronted with whether or not to sort of make their case and risk their penalty and all that. And
Yes.
that surely can't be impossible for us to also dig into. I hope we will.
That we have an opinion from Jill Remick, or a summary that's on the agenda under our documents. Abby, can you give us a brief on that?
Sure, absolutely. I know that Jill wasn't available today to talk about what she posted, which does provide all of the statutory language if the committee wanted to look at that. So the issue there relates to whenever there's a reduction, as in this case, for the town's grand list and you following a final appeal. So it's important to remember that this is not something that's still subject to an appeal. It's a final decision. There's no other recourse under law. In that case, under current statute, the town is only able to seek help for the refund that the town has to pay to the taxpayer. The town can only seek up to $100,000 from the state. And that $100,000, which is set in statute, is actually prorated amongst all municipalities in the state. So there is a cap, and it's also limited. If there's one large reduction in a town's valuation, that could wipe out that well, it could potentially wipe out the whole 100,000, but again, if other towns are requesting it, it would just reduce how much each town receives. So this has been brought up before. The legislature has considered this a few times over the last few years. There was a study that the Attorney General's office put out as well, and there were this $100,000 was actually put into statute a few sessions ago. I think the initial request had been from the administration, I think it was 3 years ago, had been for a higher amount in order to address the potential of these very high value properties being reduced. But the final dollar amount that was landed on was $100,000. So what I don't know if I'm the right person to get into the incentives of what the town will actually decide to appeal or follow through defending appeals. But part of what, as you'll see in Jill Remick's memo, what she addresses, and I think they have a report as well from the department, is that it's costly for towns to defend the appeals when they're not guaranteed a refund from the education fund because of this statute. So I don't know
So
if
they
there's
have to
questions.
pay it in. So the town has to pay the amount. If they appeal and they appeal the reduction, all right? So if they appeal the reduction and they lose, they would have to pay the property owners the difference.
That's correct.
And there is a backup fund at the state, but that's not guaranteed to be there because it's for everybody. So they risk having to raise everybody else's taxes next year to pay this off. Is that?
That's one option. Yes.
Okay.
If they were to take out loans, then they would then have to raise taxes to pay off the loans.
So it's there as a disincentive for towns, I guess, to appeal. All right. I've got Senator Saratkin and then Senator Brock.
Thank you, Madam Chair. I'm just curious, I don't know who to direct this to, but is this discussion like the cutting edge of a bigger discussion? In my committee, we're dealing with accessory dwelling units, trying to promote them for denser housing. And there's an overlay there of those kinds of short-term rentals taking away from long-term rentals, but it's what the market is happening. And if we change things in this bill, is there a precedent that it will spill over to the development of ADUs and multiple units in single-family housing where people are overhoused and we want them to perhaps break up their homes into multiple units? Do you start looking at a single-family house that's now become perhaps a triplex? Do you start looking at that as the value as a single house or the income it could yield as a triplex? Is this issue bigger than just timeshares? And I'm wondering, I guess, for Tom,
You can answer that.
What's that?
I think
Ted, I'm not,
my
Yeah.
answer to that would be that as far as the timeshare goes, these are resort vacation units. They are not residential units. So you are not taking away from potential owners of residential units or rental units. This is a vacation property and it's being used as a vacation property. And the chances of them ever being used for residential purposes are pretty slim. I'm not saying it won't happen because there are some units that probably I use residentially up in some of the resort areas, but very few of them. And part of that is because it's a resort area. It's not a residential urban area. So I don't think it's that this situation that we're talking about right now will reflect on what you're doing in your committee.
Well, we have in Burlington, for instance, plenty of short-term rentals.
Yeah.
Do you consider those permanent housing or are they vacation homes?
Well, they're an income property. The people are renting them and they're using them for, it's more of an income, like a twoplex or a triplex. You're going to be looking at it that way. But that's a whole different market than what we're talking about right now in SMUGs or in the resorts on vacation properties.
And I guess all I'm saying is it may be a totally different market, but what we do here could potentially set a precedent for this growing industry of where homes are being subdivided into multiple units.
I would say that would not be the case.
Okay.
But I don't know. I don't see that happening.
Thus, you're not renting, you're not selling 2 weeks of the year in those. You're renting it. So it's a rental property, short term. It's not, no one, there's one owner.
Okay.
I'm not seeing a connection, but
Well, I guess what I don't, if the issue here is these units, these timeshare units are lost their value and therefore the town is losing grand list value. And they want to recover that value because the unit potentially could have a better, a higher and better use as not being a timeshare. There may have been a period of time where those timeshare units 10 years ago were very valuable. And was the town valuing them at individual timeshare units? And they liked it back then. They liked valuing that. Now, because the market has disappeared for these things, now they're concerned that they're not getting enough money in property taxes. Is this something that ebbs and flows?
but the building remains the same. I think that's the problem.
Right.
And the building next door that's a condo is the same.
Right.
And so you're valuing based on kind of ownership, not on the condition of the building.
Yes, I agree. But the same people who are now complaining about valuing based upon the kind on ownership, because it's not valued very much for property taxes, were they having the same place when those things were going through the roof? When they were making a lot
So
of money.
Tom, how did you value them 10 years ago?
I was involved right at the very beginning. And in Stowe, we had 3 timeshare projects: Mountainside, Village Green, and Traps. And I had a lot of pressure on me to put them in for just what they were selling for. If a winter week was selling for $25,000 back at that time, it would go in for $25,000. If a March week was going for $3,000, put it in for $3,000. The industry did not want that. And they came up with a law that we have right now where we basically put a value on the association. You're right in the fact that there was a higher value achieved in the very beginning because you had a very good marketing scheme on selling these. We did not put them in at the exact value that they were selling for because it was a high marketing cost and there was personal property involved with it. So we dropped the value. And I went out and looked at resales at Loon Mountain and found that the resales were roughly 45 to 60% of what they were selling for as the developer was selling them, because of the high marketing cost and because of the personal property and the amenities that went with them. So I didn't put them in at what they were selling for. I put them in at that 45 to 60% value, depending on the units. So, and that was higher than what a whole unit condominium was being appraised at. And at that time, it was an industry that was booming. There was sales that could support it. Right now, you have no industry that is trying to sell these. There's no marketing out there for timeshare estates, and the people have outgrown them. They want to leave. So it's a whole different ballgame right now. Yes, if you want to follow it through, and you're going to go with the market approach, you're going to be putting these values in at $66,000 instead of $165,000 or $300,000. We have no way to prove it other than going by what the resale market is, and there is no resale market right now. So is it worth nothing? You're having a foreclosure effect in Smugs right now where they're taken back on foreclosures and people are walking away from them. So does that mean there's zero value on those timeshare estates? Who owns those timeshare estates? They basically are going to Club Wyndham. Club Wyndham is using them for a different purpose, still being a vacation property. You know, how do we value that changeover? Do we change them when Club Wyndham owns them? But if we change them when Club Wyndham owns them and get a higher value on them, that value is going to be just averaged out for the ones who own the timeshare estate still. So you're really appraising the ownership. That's what we're coming down to. And should we be appraising the ownership or should we be appraising the unit? And what the bill before you is that we're going to be appraising the unit just like we would any other whole condominium unit. And you're going to be looking at the quality, you're going to be looking at the condition, you're going to be looking at the amenities, the location, and putting a value on it depending on the size of the unit, 1 bedroom, 2 bedrooms, 3 bedrooms. So you've got a better measure on how to do it than what this measure has been in the past for the past 40 years. And I think it's probably more equitable in the long run. And equitable for the towns, for the education funds, and really for the owners. You had Dom DiCarlo come in here, and he said that the units he owned when he had the first year of the tax appeal, and he got his management fee lowered, the very next year, those management fees went right back up again on different items, not the property tax. The property tax was lower. The property tax is not the killer in the management fee. The killer is the fact that you're having somebody come in and do all the cleaning for you, doing all the repair, all the reserves are there for the furniture, for whatever else happens to that condominium, it is being fixed and kept up. And the condominiums are generally in good shape. In the condominium projects that are timeshare projects where they have been very ill designed, I've seen them go down to nothing. And you end up almost destroying that property or putting it to a different use other than condominiums because they've all been foreclosed upon and they've been wrecked. So if they're not taken care of, the value is going to come down. If they are taken care of, the value is going to sustain itself. But you have different types of ownership that own them and enjoy them. They are vacation properties. You had Don DiCarlo, you had Jim Mazur. They both said they love Smugs. They love the area. They love coming to Vermont, you know, and a lot of the people that came up here didn't love to come to Vermont. What happened was after 10 or 15 years, the kids are outgrown it. They don't want to go there anymore. The RCI exchange was not working very well. Dom said that Club Wyndham was going and buying out or having the people that own the timeshare estates to go into the Club Wyndham program. We don't know what the cost is when they do that. We're as assessors, we have found out a lot of information because of this appeal. And we're probably more knowledgeable right now than we've ever been in the past on what's happening with these entities that manage the condominiums and set the management fees for the timeshare estate owners. I understand where they're coming from. And I understand, I think, why some of them are walking away.
Okay. Senator Brock, did I see you with a question?
Yes, you did. It was a comment and it was based on our discussion of about 15 minutes ago when we were talking about the amount of money that would be available to a town to recover from the state in the event there was an overpayment of taxes and this $100,000 limit. And I just wanted to mention and raise the flag now that this case may be more widespread than what we think about and under other circumstances. And it may be something that I think we should try to take a look at this year. In particular, up my way, I've got an issue with the town of Sheldon and the valuation of some hydro dams in their town.
Mhm.
And this is a significant potential cost to a very small town that would have to pay back a very large amount of money. The issue is currently on appeal. and may not be decided this fiscal year, but they've already expended $250,000 in legal fees alone to defend this. And for small towns in Vermont, that's a big deal. The 100,000 is clearly inadequate to provide any form of backup, even if there was some kind of insurance available, which apparently there is not. So I just wanted to make sure the committee was aware of that this is going to come up in other cases as well.
And Senator Harding, I'm going to beat you to it, has a bill in that would provide towns. There was the macro digester, but small dams are a perennial problem.
Yep.
I think one of the dams, 2 towns own it, and they're using different valuation methods.
Mhm.
And I think we do need to beef up the states. One of the tax commission recommendations had to do with how we tax poles. But figuring out, if you're a small town and you've got one big factory, that can be a challenge. And we've come a long way from our locally elected listers to being a much more professional organization, but there's some expertise out there that towns can use some help with. Okay, Senator Hardy, did you have more to say on?
Yeah, I just wanted to add that I don't have a bill. What we have is a report from the tax commission about it, or the tax department about it, with some recommendations that we could put in a bill at some point.
This might be a place to attach it.
This could be the bill. Regarding this specific issue and just, all that we've heard, it does not seem fair to me that we would be assessing these properties based on ownership. It seems crazy. We don't do that in any other type of property that I can think of, but I think we should change these to be based on the value of the building itself. One of the things I'm not clear on is like the 3 different ways that Mr. Vickery talked about you can value things, which one is the most appropriate. But it doesn't seem at all fair that we would be doing this different type of valuation for these vacation properties versus our regular residential properties. And my only question is, would there need to be some kind of transition period saying, well, we're going to do that, we're going to start doing this in this year or something? I don't know. And do we need more information before we make a final decision in terms of not us, our committee, but the state? Do we need Department of Taxes to collect more information, or do we have that already? So I don't know if those are questions for Mr. Vickery or not, but.
Okay.
Can I try to answer some of those questions?
Yeah.
When we appraise them on a whole unit basis, we're looking at the unit itself. That can be argued. They can say the location's not right, the condition's not right, the quality's not right, but we have a measure that we're going by. And most condominiums, you don't do it on the income approach, you don't do it on a cost approach, you do it on a market analysis. And the only way you can keep that market analysis going is by looking at it as a whole unit. And that's in comparison. And if a person wants to appeal that, you have the basis on how you're appealing that. You can argue the condition, you can argue the quality, you can argue the location, you can argue the value of the amenities that go with it. So you put it on a plane that we can all speak to as far as a valuation problem goes. Right now, we're looking at the ownership, and I think that that's really clouding the issue. I'd like to speak on that measure that Senator Brock brought up. The draft I've read the draft that Jill and the tax department has come up with. And basically I approve of that draft because they're saying in effect, the state is going to take a hand in these appeals. They're going to hire a commercial or industrial appraiser. If a large property goes on appeal, they're going to step in and help the town. And by helping the town, if they make that decision, they're going to also forego any loss or liability in the education fund if the appeal is lost. You've taken a stand to look at how the town's appraised it. You're coming into a person that's going to judge how the town's appraised it, and you have more say in the valuation of that property and on the appeal process. Right now, you have no say. The town has no choice, if it's a lot of money that's being involved, to get out of it before the December 31st deadline. And they will. They'll do just like Smugs did. They'll stipulate to a value because it's almost an unprovable value. So why are you going to take the chance of paying back hundreds of thousands of dollars in education liability as a result of the loss of the appeal? So I very much like the draft that I saw that Jill in the tax department was coming up with. It does give you as a state a finger in what's being done and how the appeals are being handled. And by you taking a hand in that, you're also taking a hand in the liability of the education fund lost. I'm all for that. And you're going to end up with a better system by doing that. You know, when I was with PV&R way back in the 60s, we had industrial appraisers in PV&R. We had commercial appraisals in PV&R. You have no commercial appraisal or industrial appraiser in PV&R right now. That draft that I saw did allow for the hiring of an industrial or commercial appraiser to help the towns that have an appeal like this. But you're also taking a hand in, if you lose the appeal, the town's not going to be stuck with the education loss. The state has been part of it. And that liability is gone from the town.
Can I just clarify, Mr. Vickery, can I just clarify, because you're talking about the draft that Jill has. Are you talking about an actual draft or the department's report to us about this issue?
I think I saw the draft report.
Okay, I'm trying to find it on our website. I know do you know where it is, Faith, by any chance?
It came across. I remember seeing it.
Yeah.
We'll find it.
Okay.
And repost.
Yeah, all I've
This
seen
may
is,
be a place to put it into bill draft form.
I've seen the draft. I haven't seen what the final draft was, but I
Okay.
like the concept of what they were trying to do.
Yeah. Okay. So I'll make sure Faith knows what we're looking for and we'll find it. All right. I think they came from the tax department, if I remember correctly, like at the beginning of the session, may even been just before the session, but we'll find them. Okay. I think that's it for today. Thank you, Mr. Vickery.
I will try to get an answer on that California law and check into other
That
states.
would be helpful. Yeah,
All right.
because we can't be the only place. I mean,
Sure you can be.
well, yeah, but it'll get to them too. There are Wyoming and some places have those kinds of timeshares. All right, committee. I'm going to take we're 5 minutes fast, but Abby's still here. And we just have a draft of the municipal retention of property tax bill, which we decided already was the law, but this makes it clearer. Is that okay? So you want to walk us through that one? Maybe we can have a success today.
Resolution. Yes, I'm just trying to pull
Resolution.
the language. And I did just forward the report to Faith.
Thank you.
We have a nice report search function on the website. Okay.
Oh, Senator Hardy just perked up. I think you need to help her find that.
No, she sent it to me, but I did look for the report search. How did you find it, Abby? Because
I think you can do this offline. Abby can help you find the
All right.
reports.
Sure. I just searched for the Department of Taxes. That's the easiest.
Okay.
I thought
Um,
that's where it came from. Okay.
I'm sorry, I'm not, sorry. Faith, I'm not sure that the rewrite language has been posted. Should I resend that to you? I've sent you so many documents, I'm sorry.
My apologies, Abby. I will screen share if I can find it quickly.
Okay, so I'm sorry, I just saw so many, I didn't.
No, for
all of
simple
them.
little bill, there's been a lot of drafts floating back and forth. For a bill that's not necessary.
Abby, it looks like I haven't posted it. Could you resend it to me, please?
Yes, I am resending it now, I'm sorry about that. Okay, I could also share my screen if the committee would like me to do that while. Faith
Okay,
is
yeah, and
posting.
then we'll get it to Faith and she can get it up. But for now, it'd probably be best just to share screen.
It did also go, it should be in your emails as well, so I will share that.
Okay, if you make it a little larger, we'll be good to go. Oh, good and large. Okay.
Okay, excellent. So this is draft 1.1, not drafted currently as an amendment to the bill. Your committee had discussed S-261, so that was the portion of education taxes collected that towns are allowed to retain. And under a very literal interpretation of the statute, my understanding was that it was only allowed to those towns that pay education taxes directly to the state. Since Act 60, it has been interpreted to apply to every town, so that every town that's collecting and paying education taxes, paying them either to the state or to the school district, will be able to retain the 0.225% of the taxes collected. It's taken off in the accounting process when towns are paying AOE or the school district. So that might have been the source of the confusion from certain towns not realizing that they were getting that little portion that they could retain instead of paying it over to the state. So I had recommended just clarifying this section that has been what the Agency of Education has interpreted as allowing them to let towns keep a portion of their taxes collected. I had just tried to clarify it a little bit to make it clear that it's not just for the towns paying the treasurer, the state treasurer directly. So this adds it splits out subsection C. So it adds a new subdivision 1. It makes a little capitalization change. And really the big changes in the new subdivision 2, it adds in language where it's clear that each municipality, so it's not just specific to the municipality that's paying the state treasurer directly, it's each municipality may retain 0.225 of 1% of the total education tax collected, only upon timely remittance of net payment to the state treasurer. Then the new language is or to the applicable school district or districts. Again, there's a strikeout adding in each to make it clear that it's each municipality may also retain $15 for late property tax credit claims filed after a certain date. So that's really the extent of the change. It's clarifying this is what's already being done under current law. At your request, Madam Chair, I did share it with PVR and the Agency of Education, and they can weigh in if you'd like. They did say that they were okay with these changes too.
Okay.
Let me know that.
Okay. So committee.
Madam Chair?
Question? Yes. Senator
So are
Pearson.
you considering just advancing this bill or tacking this into something else, or what's your thinking?
I'm thinking of advancing this bill, and I don't know, would this be a strike all amendment?
That's how I could draft it if you would like. Yes, there was another provision providing for penalties, which also would be unnecessary given the current law.
And just to clarify, because I serve with Senator Parent in the morning, this bill is totally unnecessary, but we're making it crystal clear. Is that, I mean, it won't have, I'm being cheeky, but it has no impact on what towns will get or the ed fund or anything.
Right.
But
That's correct.
we're in fact letting Senator Parent and others, people that work in municipalities understand that they've been getting this money right along.
Yeah, even though it was listed under sending towns or, so we're just, this has been the practice since Act 60, and we are just making it clear that we're making the practice legal.
Thank
If
you.
it ever wasn't, but it's not changing anything at this point from current practice. Senator Hardy.
Thanks, Madam Chair. Well, one, I don't see the bill on the website. Is it up there yet? I had a question about the language and I wanted to look at it to see it.
Well,
but-
the bill is S-261 and
Yeah, but that's as introduced. I don't. see-
yeah, okay, well, there it
Okay.
is.
Can you
up
make it
on
a
the
little
screen.
bigger, Abby?
Or I'm not sure
So,
if it's Abby or
yeah,
Faith doing it.
Paragraph 2, that, so if each minute, so the towns pay, some towns pay into the education fund. Some towns, all towns get things back from the education fund, and then towns pay the school districts. So when is it that the municipality retains the 0.225? In which transaction is that retained?
Is Abby, is,
Right. That might be more of a Brad James question, because I know
Yeah.
that he is, I've seen the form, but I don't know that I'm the right person to answer that, because I know this is happening throughout, there are a couple of different payment dates. So I think it happens throughout the year, but that's not, really laid out in statute.
Okay, I just want to make sure that when we're clarifying it, we're not making it, if the towns don't already know that this is happening, it's sort of buried in there somewhere. I wouldn't want to confuse the situation and have them retain it when they're paying the school districts if
No,
it's
it's
already
all-
been retained somewhere else. And so at
Mhm.
0.225 turns out to be 0.45.
So it is upon timely remittance of the payment. So that, I understand that would be at the time when the payment is due. So when it's paid to school districts, it's a different date than when it's paid to the state treasurer. My understanding is it's all going through AOE. They're calculating how much the town owes, and then the retention is calculated at the same time.
Okay, so
I
AO
don't-
is doing the calculating, not the
That's right.
towns themselves. Oh, okay.
That's
Okay.
right.
And I guess, Madam Chair, from a logistical, I would prefer that we just tack this on to something else if we have a miscellaneous tax bill or something else as a package, not just advancing this bill individually.
oh. Okay, it just means it's not going to get out. Miscellaneous tax is usually the last bill to go, and I don't know if we've got another bill to tack this on. So committee, what is your pleasure? My inclination would be to ask Abby to draft this as a strike all and to get it out so the towns know what's happening, but because we may be able to put it on a miscellaneous tax, but that would delay it until we go home.
Depends on how much attention we want to bring to the fact that some towns will get a pile of money out of this and other towns will get practically zero.
Nobody's gonna
No.
get it's not gonna change
Anything.
anything. There's no rush to do this because it's not changing anything.
It's just making it clear. So Senator Hardy, why would you not want to send it?
Well, it just seems to me that, when we put together a package of individual items that, people want different things, it helps move a package forward.
Okay.
And so, we all get a
It
little.
does, yeah.
That's what my thought is, that, it might be helpful.
Well, why don't we have Abby start out drafting this as a strike all? And then we can take a look at it and you can all think about whether or not you want to send it. This isn't a bill that it doesn't change anything, so nobody really wants it or doesn't want it. It's just clarifying language, but no one's making or losing. They're getting it whether they know it or not. It's calculated in. All right. Any further discussion? That is all we have on the agenda for today. We thought chairs was at 4. It's been moved to 4:15. So I will see some of you there. But I think that's it, unless anyone else has an issue they'd like to bring up at this point. We will send to Pearson.
Madam Chair, did the suggestions around the income tax for schools make sense? I sent those to you in faith at your request.
Yeah, I think we've got them on, or we're trying to get them on for Friday, depending on how much time. And apparently Deb Brighton has something to bring to us. So we're trying to get them all on for Friday. Okay.
Okay.
Or, if we don't have time Friday, we'll spill it over into next week.
Yeah, well, there comes a point where we may not bother taking up time if it's much longer, but Faith, there is a typo on Friday that's part of my confusion. That says the 11th, but all right, thank you.
We have a typo on Friday. Oh, yes, that was last week. It's the issues of cut and paste in this world. Okay, all right. I will see everybody tomorrow. We can go off live tomorrow. We're going to be looking at waiting. Back to corporate income tax. Representative Kornheiser. No, we're going to be looking at the military exemption, and Representative Kornheiser is going to talk to us about the reason they put it on, and then we're going to go into civil service retirement. We're back to waiting. I guess that's around I'm not sure what that's around. We're working around people's schedules, and we're back on waiting on Thursday. And then we're on to construction work sites, communications. So
Ending live stream now.
we are out.